Topic of discussion for today is called Planning and Precision in Parenting Orders, a drafting guide. And indeed, that's what it's intended to be. The theme of what I'd like to speak to you about this morning is about keeping our eye on the prize. As legal representatives and professionals working in this space, part of what we do, a lot of what we do, is drafting documents, drafting orders. And today in particular, I want to focus on drafting enforceable parenting orders and parenting plans and some of the tips and traps in that. Why is it important? Well, what should be and what are the parenting arrangements for children in separated families is often a hotly disputed issue between parents and carers of kids. And rightly so. We love our kids. They're the centre of our lives. And when things go wrong in separated families, dispute often arises. For those parents who are in dispute and who want to resolve things, they look to us as their family lawyers for the purposes of asking us to deliver a product. The product is a suite of enforceable parenting orders or a parenting plan. And so as we deliver that product, it's fundamentally important that we get it right. That what's included in the product is a set of clear, unambiguous, and hopefully enforceable parenting orders, or a clear parenting plan, if that's what parties have chosen to do, which they can live by and move forward into the future. A product which reduces that conflict, minimises disruption going forward, and prevents kids from being exposed to conflict. So that's our obligation. As we track through today, we'll look at some fundamental principles or building blocks of what makes a good and enforceable parenting order and how to go about doing it. But before we get there, I thought, given the changes to the law that we've now been living by for about the last 2 months, I thought it'd be a good time as well just to do a bit of a refresher on what the new law in Part 7 relating to parenting actually is and what it means. Hopefully we're all familiar with it, given it has been in place now for about 2 months, but as a refresher, let's just track through that quickly now. So changes are coming. In fact, it's now upon us. The Family Law Amendment Act 2023 was passed in November last year and commenced on the 6th of May this year. It applies to all parenting proceedings instituted in courts on or after the 6th of May 2024, as well as all parenting proceedings that have already been on foot before that date. But the exception is this: if there are matters for where a final hearing has already commenced, the new law, of course, doesn't apply to that. I would anticipate now that probably only applies to matters which perhaps are standing adjourned on a part heard basis, and that will resume, being matters that did start before the 6th of May. So what's changed? Let's just do a bit of a refresher there. Firstly, we've seen a simplification of the objects of the Act through the introduction of the amendments to the Family Law Act. There are now only 2 objects. The first is to ensure that the best interests of children are met, including by ensuring their safety. And secondly, the second object is to give effect to the Convention on the Rights of the Child done at New York on 20 November 1989. So already when we reflect back on the numerous objects that were in the previous version of the Family Law Act, the simplification means that we now have 2, and essentially it's to refocus on the best interests of children and to make things simple. Of course, we have new Section 60cc2 factors. The old series of factors, which had the additional and primary considerations at Section 60cc, are now gone. We now have a complete set of new 6 factors. The new 6 factors that have been picked up are essentially those that were recommended by the ALRC in 2019. And when you read them, unlike the prior version of the Family Law Act we had before May this year, they are non-hierarchical. There is no focus on primary or additional. This enables the court to deal with matters with a greater level of discretion, in my view, accommodating the specific and unique circumstances of children in each particular matter. It's intended to make things more simple for the users of the court system who need to resolve parenting orders. It's intended to keep a focus on the best interests of children by tracking parents through a series of only 6 factors, plus a few extra things that we'll see in a moment. So what are the factors? Well, the first one is to promote safety, including safety from being subjected to or exposed to family violence, abuse, neglect, or other harm of the child, certainly, but importantly, of each other person who has care of the child. That might include parents, it might include carers. It certainly is intended to address that situation of where there might be exposure of family violence risk at the point of changeover, or if orders are crafted that bring perpetrator and victim into contact with one another. So that's the first factor. The second factor under Section 60cc2, as we now know it, is any views expressed by the child. And certainly this is something we had in the former iteration of the Family Law Act, but in the new fashion, perhaps helpfully or unhelpfully, I'm not quite sure yet, we'll see over time, the provision around why children express those views or what might be influencing those views is not written into statute, but I would hold the view will still be certainly examined by trial judges in matters where that becomes relevant. Thirdly, the developmental, psychological, emotional and cultural needs of the child are certainly at the forefront here in determining what's in their best interests. Next, the capacity of each person who has or is proposed to have parental responsibility for the child to provide for the developmental, psychological, emotional and cultural needs of the child. Again, a carryover from the former legislation with a focus on capacity, but with particular areas to examine. Fifthly, the benefit to the child of being able to have a relationship with the child's parents and other people who are significant to the child, but where it's safe to do so. And I just pause there and focus your attention on those words, where it's safe to do so. As you'll see this morning as we track through, the issue of what is safe and safety of children seems to carry through a number of changes that have occurred. We're yet to see what it actually means when we talk about what is safe for children. And then factor number 6, anything else that is relevant to the particular circumstances of the child. So a catch-all, and whilst we might only have a refined suite of 6 considerations under the new Section 60cc, the catch-all is certainly there to enable trial judges and us lawyers when taking instructions to pick up and include a consideration of anything else that's relevant in the circumstances of the child or children that we're dealing with in our particular matter. The Amendment Act also includes now in the Family Law Act, Section 60cc capital 2A, which requires the court, when considering the new factors, to also look at any history of family violence, abuse or neglect involving a child or carer. It doesn't say who against or who directed towards, but certainly the history of family violence involving those people. And secondly, any family violence orders that apply or have applied. And there we have a focus and need to ensure we're continuing to put before the court evidence of existing ADVO or DVO orders, depending on which state or territory you're in, and historical ones as well. Before we move on, it's interesting that the Act also tailors provisions specifically for children who may be of Aboriginal and Torres Strait Islander descent, allowing the court specifically to take into account features of their heritage, culture, and need to maintain connections with community. So if you are dealing with children of Aboriginal or Torres Strait Islander descent, please don't forget to check the legislation as it now exists in relation to specific matters involving those children. Aside from a new series of 6 factors, we have importantly under the new legislation the repeal of the former presumption of equal shared parental responsibility. This is important. One of the reasons why we know that occurred with the change to the law is because under the old legislation, there was certainly some level of misunderstanding within the community around the concept of equal shared parental responsibility equating to equal time. And so through the amendment to the legislation, there's a strong communication to the community that there is no presumption that equal time arrangements should be or will be dispensed by the court necessarily in each matter, simply if parents are required to make joint decisions. In relation to the abolition of the presumption of equal shared parental responsibility, we now, of course, are left in a situation where the starting point has to be and must be the statutory position, which is set out at section 61C of the Act. That, of course, being a provision which says that absent there being a court order in place, parents of children each have parental responsibility for their children. And with that parental responsibility, they are entitled to make decisions in relation to their children about major long-term issues, either with consultation of the other parent involved or individually. It is, of course, only if there is an order made reallocating parental responsibility or mandating the concept of joint decision-making that the statutory position will be altered. Under the new changes, we have, of course, encouragement from the legislature that parents should be encouraged to consult one another to make major long-term decisions, but not mandated necessarily through an application of presumption of equal shared parental responsibility to do so. Through the introduction of what is section 61D3, the Family Law Act now provides that a parenting order that deals with the allocation of responsibility for making decisions about major long-term issues may provide for this concept of joint or sole decision-making. So just pausing there, already when we think about how we go about drafting our parenting orders relating to the issue of parental responsibility, we have to utilise new language. The new language is that the parents shall have joint decision-making responsibility in relation to major long-term issues for their child, if that's what's agreed or that's what's to be sought. The introduction of these new changes provides a clarification, I think, for parents that if an order is made for this joint decision-making, what does actually require people to do? Well, statute tells us at 61DAA that parents need to consult one another in relation to that decision about a major long-term issue, and they must make a genuine effort to make a joint decision. In the event they can't come to a joint decision, of course, the court retains its residual power to intervene at that point upon further application to make the decision about the specific issue for that child or children involved. It's interesting because before, with the presumption of equal shared parental responsibility, parents often didn't really know what that meant they had to do unless they were clearly advised. And indeed, I've experienced matters within my own file load whereby there have been contraventions brought simply because a parent didn't understand that obligation to consult and make joint decisions. Perhaps they weren't advised properly originally, I don't know. But under the new legislation, helpfully, it sets out what parents need to do to fulfil their obligations in that respect. The legislation also reminds parents that there is certainly no obligation to consult and make joint decisions in relation to things that are not major long-term decisions as defined by the legislation, and certainly day-to-day decision-making for kids in terms of what they wear, what they do, etc., are all things that can certainly be done by a parent who has the care of the children at that time without necessary consultation to the other parent. Of course, the court still retains the power to reallocate parental responsibility and to make orders for sole parental responsibility. In certain cases, that is appropriate and should be applied for. And those are matters that shouldn't be confused with joint decision-making obligations. Moving forward then, with the changes that have been brought about, particularly the abolition of the presumption of equal shared parental responsibility, the prior mandatory considerations for the court to consider in contested matters equal time and substantial and significant time constructs are out. That does not mean that we as lawyers helping parties to resolve disputes can't think about and design outcomes for equal time or substantial and significant time arrangements. It just means that the court in contested matters doesn't have to track through a pathway whereby they consider whether or not equal time and substantial and significant time arrangements are in the best interests of children and, of course, reasonably practicable. The amendments also bring about changes to advisor obligations imposed upon lawyers, FDRPs, family counsellors. Under the old legislation, advisors were required to operate within a framework of looking at best interests of kids with a focus on a meaningful relationship with each parent being something that fulfills their best interests. That's certainly gone. The focus and mandate on all advisors, including us lawyers, is simply to focus on designing solutions that are in the best interests of children, with a focus on their particular circumstances and their particular needs. Tracking forward, the new changes, of course, bring into account a codification now in statute in the Family Law Act of the rule in Rice and Aspland. We all know, and we've all used the words, has there been a significant change in circumstances to warrant the court reopening a matter once a final parenting order has been made? What we now see in the legislation at 65D is that codification, a mandate that the court must not consider reopening a matter and making a variation or modification to a final parenting order unless the court has first considered and satisfied itself that there has been a change of a significant nature in circumstances since the final order was made. And then secondly, that the court is satisfied in those circumstances that the modification being proposed is in the best interests of children. I think really helpfully for us lawyers who are faced with Rice and Aspland applications is that the Family Law Act, as we now have, provides a series of considerations around what the court might look at to determine whether or not there has been a significant change in circumstances. Those are set out in the legislation. They include the reasons for the final parenting order having been made and the material upon which it was based. Whether or not any new material has come to light since that first material was relied upon. Thirdly, whether or not if the court would open the doors and allow parents back in to make an application to vary, discharge or modify an existing final parenting order, the likelihood that the existing final parenting order would in fact be changed in some particular way. And then, of course, the benefit or detriment to the child or children involved in having their parents involved in a further dispute about them. And so, of course, I think those new particular focus areas give us some guidance on how to craft evidence when preparing for a Rice and Aspland challenge or when indeed opposing a Rice and Aspland style application. It is, of course, important to note that under the new legislation, there is, of course, a provision allowing the court to make orders by consent, which might vary or discharge an existing final parenting order, giving parties freedom to come up with new arrangements for their children as they might agree upon. That's the new law. Bit of a refresher. What I want to now do is just change focus and look now and focus on the issue of drafting. And in understanding what a parenting order that we might be drafting is aiming to achieve, I think it's helpful to go back to base principles and to think about, well, what is a parenting order? What is it? Why do we do it? A parenting order really is an order of the court that deals with a topic area referred to at section 64B of the Family Law Act. There you will find the topics that the court can make parenting orders about. And they include these things: a person or persons with whom a child might live, the time the child is to spend with those other people important in their life, allocation of parental responsibility, as we've touched upon, communication, maintenance of a child, steps to be taken before a parenting dispute comes back to court, and also catch-all, any other aspect of the care, welfare, and development of children. So that's the subject matter that we'd have to think about, focus on, tailor our parenting order to. But why? Why do people want parenting orders and what are they aiming to achieve? I guess I'd suggest these are the 4 aspects of the prize we need to keep our eye on when drafting. Firstly, we want our parenting order to create certainty of arrangements for parents and kids to end their dispute. So parents know what it is that's going on in terms of little Johnny or Kate regarding activities, arrangements, living arrangements, care arrangements in the life of that child. That certainty is fundamentally important. Why? Secondly, it's going to minimise conflict in that family. It will end the dispute. And hopefully, by virtue of doing that, reduce the exposure or risk exposure of the children involved in that matter to conflict in their life, particularly conflict they're exposed to between parents or carers. The third prize that we're really looking at is having clarity and certainty of the legal obligations being imposed upon parents and carers, making sure they know what it is they have to do. What rule book do they have to live by? Making it as clear as possible for them. Then fourthly, why would we do a parenting order? Why would we advise clients do a parenting order and have some made? To create some mechanism for enforceability, allowing parents to approach a court to complain and allege that the other parent hasn't complied and that because of that, some sanction should apply. A sanction either to educate, re-educate, inform the other parent, hopefully to bring about change, or alternatively, a sanction to impose a penalty as a mechanism by which compliance might then be achieved in the future. I suggest those are really the four prizes, the goals of why we do parenting orders and what we want our parenting orders to achieve. So what are the fundamental building blocks of getting there? Going back to base principles, this is what I do when I'm drafting a parenting order. I sit there and I say to myself, have I covered the what? Have I covered the who? Have I covered the when? Have I covered the how? Have I covered the where in each parenting order that I might draft? Let me explain what I mean. The what. The what is really the subject matter of what I'm trying to aim and target my parenting order to achieve. Is this an order about live with? Is this an order about time? Is this an order about communication? Is it an order about joint decision making? If it is, making that clear as the subject matter of the order. If I'm drafting a suite of really long orders in a complicated matter, it might be helpful that I import into my suite of orders subject headings. That will certainly, I think, help the reader of those orders, parents and carers, to quickly have a ready reckoner to where they've got to look to understand what's to occur as to a particular subject matter. Secondly, the who. It's really important that when we're drafting parenting orders, we don't just deal with subject matter in the abstract. We have to be drafting orders in personam. That means against a person, requiring that person to do something. Drafting in personam means that we can easily identify and allege who it is that's breached a parenting order and therefore who the respondent to any contravention application, should there be an issue of enforceability, is. It might be the father, it might be someone else, but clearly identifying that person and making sure the order's drafting it in personam as opposed to being drafted in rem, we call it, is really important. Mostly, parenting orders need to include a provision about when that person, who is the who, does that thing that is the what. When might be referenced to a date. When might be referenced to a time. When might be referenced to a period of time. But whatever it is, clearly having when they have to do something by is necessary in order to prove that breach of order, as opposed to a vague order requiring something to happen at an unspecified point in time, meaning that no one knows if someone's actually complied and discharged their obligations under the order or otherwise. Parenting orders usually have a provision about how. Let me give you some examples. If we're dealing around changeover, how is it to happen for kids? If we're dealing around travel arrangements, either nationally or internationally, how is that to happen? And if you unpack that, there's a fair bit of detail in all of those topic areas, and we'll address some of them in some of the case examples to follow this morning. But the how's super important to make sure we know how something is to occur and what was supposed to occur in that respect. And then finally, where. What is the place at which this person is to do the thing at a particular point in time to fulfill their obligations? Place might be specified as a location with reference to suburb, building, address, country. But in your particular matter, it's really critical, in my view, to be thinking about, in terms of the where, is there likely to be dispute between the parents about where? And if so, do I need to drill down to being really quite specific about that to ensure there's no dispute and to ensure there's no allegation of non-compliance? So just by way of summary there, drafting in personam and not rem, please be reminded of that. As we draft through the instructions that we've been given, double check always they accord with your instructions, that you're getting it right, that you've got reference to a file note, a record of interview, an email, or something from which our instructions emanate. Once we've drafted, I'd recommend always that we check for internal inconsistencies. Is there any contradiction? Is there any overlap? Is there something there that means that I'll point to order 7 to allege non-compliance, but the other side will point to order 20, which, oops, was drafted incorrectly. It's contradictory to order 7. We're in trouble. And also, do these orders that I've drafted, do they operate as intended? What I mean there is, can we do a bit of a reality test? What I often do once I've drafted a suite of parenting orders, whether it's property or parenting, as we're talking about today, I'll probably sit back and just model them under certain examples, make sure they work. i.e., I've got little Johnny going on an overseas holiday coming up. How's it going to happen? Have we covered off delivery to an airport? Have we covered off transiting to the other side of the world? Have we covered off passport applications? Have we covered off notice about where little Johnny's going to be? All of that kind of stuff. Just reality testing in my mind the issues that I know were of dispute and making sure my suite of parenting orders have covered those things and therefore go to some way to meeting that prize. I'm often asked as a practitioner, sometimes by judges, sometimes by other lawyers, how detailed should orders be? I don't think there's one answer to that. I don't think, in fact, one size fits all in any of these situations. And so inevitably, my response has to be, it depends. What does it depend on? Well, it depends on a whole bunch of stuff. Firstly, I think it depends on the subject matter. If there's lots of topics that we've got to cover off in a suite of parenting orders, then the reality will be that my orders will be long. I've got to deal with all those things. It might be live with, time, allocation of parental responsibility, joint decision-making, communication, travel. If I'm dealing with matters involving drug testing, inevitably those orders are going to be long, alcohol testing the same. If I'm dealing with matters in relation to relocation, inevitably that might be trickier. So certainly the subject matter is something which will dictate the length and level of detail in parenting orders. But importantly, I think we've also got to sit and pause as prudent practitioners and say, what sort of parents are these people? Are they highly cooperative? Are they focused on actually getting on and living life? Or are they parents who are likely to be tricky with one another and the law, or troublemaker parents? If they are, then I think inevitably our parenting orders will need to descend to a level of detail that perhaps is perhaps more fulsome, covering all different scenarios, almost thinking, where will the tricky play come and what do I need to protect my client against? Some other things there. Parents sometimes cooperate and be flexible to work things through, and for those people, a minimalist suite of parenting orders in a really casual setting might be sufficient. I'm finding, though, in my practice that more and more the incidence of mental health, personality disorders, stresses in people's life are making things more difficult. They're driving behaviour that's unpredictable and unusual. And in those settings, having a discussion with my client around what do we expect will be the landscape once these orders are operating and thinking about how detailed do these people want these orders to be is important. But I think it's also important to reflect upon the level of sophistication of our clients. Some clients struggle to read, others are highly sophisticated. Some don't actually know what things mean unless explained to them and reminded to them time and time again. Sometimes having a really detailed suite of parenting orders that clients simply can't understand or forget about is useless. So it's finding that right balance that tailors to the personalities, the levels of intellect and sophistication involved in a matter. I think also the past can inform the future. Has there been a history of non-compliance or bad behaviour by that parent to date? If there has been, and you're planning or expecting for more enforcement action through the filing of contravention applications, then of course it makes sense for your orders to be more detailed than perhaps otherwise necessary and really covering all bases. The age and characteristics of kids also, in my experience, dictates how detailed orders should be or might be. Let me give you some examples. Really young kids, babies, it might be that parents are designing a suite of parenting orders that are intended to endure over some years as that child or children matures in age and goes through different developmental milestones or steps. Those orders might be quite detailed. They might be drafted in phases that are age specific and changing in a graduated pattern of incremental increasing amounts of time, for example, with a parent. For young children, there might be some logistical stuff around parenting, bedtimes, food provision, notification, discussion with parents and sharing of information that needs to be covered in our suite of parenting orders. On the other end of the spectrum, older kids, teenage kids. Some might subscribe to the view that when kids are teenagers, orders should be drafted in a minimal way. That is, for example, that a child spend time with or her parents in accordance with their views and wishes. It might be an order which mandates parents to facilitate and encourage and not obstruct teenage kids from spending time or living across two households. I don't necessarily think, however, that in all cases, allowing kids to call the shots and for time or living arrangements to be dictated by them is the answer. We've all seen those cases whereby there might be some pressure or influence by a parent or an unhealthy alignment of a child with a parent, or even at the worst case, some attempt at parental alienation of an older teenage child. In those sorts of cases, it might be helpful, particularly if recommended by an expert report writer, to think about more detailed orders which might operate in a way so as to provide some scaffolding around that child to allow that child to explore and have a relationship with the other parent, notwithstanding unfair or inappropriate influence by the first parent, which might ordinarily disable them from being able to express a view, a desire to spend time with the other parent, or to be free to do that without fear of criticism or reprimand by the parent who's perhaps causing difficulty. By scaffold, I mean providing orders for time for that teenage child to occur, but provisions as well for time to be modified in the event the child expresses a view, a desire, a wish that's different, allowing the child to say and know about those orders, giving them permission to spend time, even though it may not be something approved of by the other parent. So really, again, not a one-size-fits-all approach, and certainly something that we need to think about specifically with those factors in mind. Why are some orders enforceable? Well, poor drafting. They're unclear. They're ambiguous. The subject matter's not been identified. The person who's bound by the order isn't stated. The time that something is to occur hasn't been prescribed. Those are all poor drafting issues that commonly come to light when enforcement action needs to be taken, and embarrassingly could be the subject of a complaint or even a negligence allegation on the part of the lawyer who drafted those orders. Sometimes orders can't be enforced, not because they're drafted poorly, but perhaps because the subject matter of them is hard to address or hard to prove if there's been a breach. For example, orders which might restrain a parent from doing something in the privacy of their own home when they have care of children with them might be hard for the other parent to prove if they're not there watching, hearing, seeing, observing what's going on. things that are hard to police. So even if we are including those in our suite of parenting orders, I think it's helpful that we provide advice to our clients about difficulties that might arise in policing behaviour, even if that behaviour is sought to be regulated by a parenting order. Orders that are unenforceable are also those orders that attempt to bind or drag in third parties who haven't been parties to the contested proceedings or haven't signed up to the consent orders that have been made. So just take care around those things. And also orders which might exceed the court's jurisdiction. And commonly in this space, when we're focusing on drafting of parenting orders, I see occasionally solicitors attempting to import into their suite of parenting orders which really, by definition, are child support orders that deal with responsibility to pay money from one parent to the other for the benefit of the child. I get why it happens, but unless parenting proceedings are on foot at the same time as jurisdiction being invoked on child support matters, we really need to take care around importing financial obligations into suites of parenting orders. So let's now just spend a little bit of time going through some specific topic areas or examples where drafting needs to be considered. The first topic area I want to talk about in relation to parenting is relocation cases. When coming to drafting of either applications or suites of consent orders, remember the order permitting relocation, if that's what we desire or have agreed, is not an order about where the other parent lives, as opposed to an order that is framed allowing a parent to relocate or change the usual place of residence of a child. That's the key there with our drafting. But not just that. You need to think about, when does that relocation happen? Is it something that's to happen immediately? If so, draft it in our orders. If the permission to relocate is not something that's to occur for some time into the future, again, put that in the orders. Think about if the relocation is to be temporary or permanent. I'm certainly seeing more and more cases with international families whereby there are relocations of a child's usual place of residence only for a limited time. And in those cases, my orders need to be drafted to provide for when the child is returned to the originating jurisdiction, how that's to occur, and what's to occur in terms of that child's living arrangements when he or she returns to that original jurisdiction. So thinking through the steps of the relocation. Inherent in any relocation matter, I would suggest, is then the complicating issue of time that the child, once relocated, will spend with the other parent. And that, I think, leads us to some consideration about devil in the detail for holiday and travel orders. Let's just talk about that for a minute. Firstly, in relation to holiday orders, we all know, and rational and sensible people know, what a school holiday period is, but that can be very different for different people in different settings. I think in any orders about school holidays, we need to and we should be including in our orders a definition of what holidays are. Holidays might be referenced to the school at which the child attends, as opposed to some nebulous concept of gazetted school holiday periods, not that any such thing necessarily exists. Secondly, when we're looking at what a school holiday period is and how it dovetails in with usual term time arrangements for children, care needs to be taken to ensure that our suite of orders clearly specify when school holidays start and what happens at the end of those school holidays in terms of the recommencement of what might be suspended term time arrangements. Here I'm talking about a clause which says that usual term time arrangements for children are suspended during holiday periods, but are to recommence as follows. When looking at that recommencement of term time arrangements after school holiday periods, care also needs to be taken about how the pattern of term time arrangements might recommence. More and more clients that I'm dealing with these days, because of work arrangements, needing to pre-plan, but also blended families who seek to align time arrangements with children from one family and the other. They're wanting to pre-plan such that term time arrangements which occurred before a holiday recommence in the same pattern or configuration of weeks or alternate weekends that pre-existed before the holiday period commenced. If that's your client, care needs to be taken to include an order to that effect in your suite of orders. Otherwise, following the recommencement of a term period after a holiday, all sorts of chaos could arise and a complaint could come forward that you've rejigged the alternate weekend pattern or whatever it may well be, and that causes some difficulty or dispute. When defining a holiday period, my recommendation would be to give thought to whether or not you define the first day of a holiday period with reference to whether or not that's the conclusion of school on the last day the child attends school or the next day. And similarly, to define the last day of a school holiday period. Doing that will also enable parties to clearly identify, for example, what is the halfway point throughout a holiday period, that being relevant if school holidays are being shared equally. But even then, when we divide school holidays by two, often there's two middle days. And in high conflict families, they often squabble about which middle day changeovers to occur. So defining which middle day and including that in a suite of orders is sometimes necessary and useful. And remembering as well, time for changeover on those days can be key. In terms of holidays, here are some things to think about and include as the subject matter of your suite of parenting orders when it comes to travel. Firstly, it might be where the child is going. Notice about that travel. It might be around who is to book the tickets for travel. It might be around how those tickets are to come into the possession of the other party. It might be around arranging travel insurance and carrying forward valid policies for hospital extras cover for that child if they're going to a place where the cost of medical care might be astronomical. It might be around giving notice for countries, places, overnight stays. It might be limiting which countries children travel to with reference to, for example, Hague Convention countries, countries where travel alerts might be acceptable to the parents involved in that matter, or it might be generally anywhere in the world. For kids that are travelling, it might be obligations on parents to deliver children to airports, to facilitate their smooth passage through immigration and customs. It might be for the other parent to be waiting at the arrivals lounge in the destination country. It might be an order for unaccompanied minor travel. If I'm dealing with a family who has a suite or is intending to have a suite of parenting orders, remembering to include permission to travel overseas so as not to be in breach of the statutory prohibition on overseas travel unless it's with the consent authenticated and prescribed or pursuant to a court order that we read in the legislation. In relation to travel internationally, thought needs to be given to travel passports, visas, and having orders around how those things might not only be applied for in advance of the intended travel, but also how those documents are to be retained once travel has occurred. On an interim basis, where there's risk of children being abducted or similar, think about the safe custody of those documents. In families who hopefully are leaving their interaction with legal advisors because they're moving on into the future with a suite of final parenting orders, it might be around which parent retains those travel documents and how they might be shared between parents and come into possession of the other parent when travel is to arise. Nothing more embarrassing than a client saying, I'm planning travel, but they can't get passports, or there's no obligation on parents to join with the other parent in making application for passports within a fixed period of time in advance of that travel that's occurred. I just want to focus then on changeover arrangements. Often we simply include in our suites of orders where changeover is to occur and where it's to occur by reference to a place. With matters becoming more and more complex and the focus on family violence and making sure arrangements are safe, not only for children, but parties, I'd certainly be mindful of canvassing with my client how they feel about being involved in changeover, whether or not there's any risk to them or children, with changeover occurring either in private spaces or whether or not they need to move to public spaces. And further, who should be involved in changeover? With reference to my comment around not binding third parties to parenting orders, one shouldn't necessarily jump to saying granny or friend will be involved in changeover and attempting to impose obligations on them in parenting orders to fulfil changeover obligations. If they're not parties to proceedings, that shouldn't happen, can't occur, they won't be bound to it. Orders might need to be more carefully drafted, which impose upon a parent an obligation to facilitate changeover either directly or via their nominee. That enables them the power to then say, well, I'm going to invite someone else to participate and affect that changeover if that's necessary or appropriate. In terms of changeover arrangements, more and more, perhaps more so than ever, I'm drafting orders even in consent cases whereby changeover is to occur at a curbside or at the front driveway of the parties' homes, or in more higher risk situations in public venues. If that's the case, putting restraints on behaviour of people at that changeover event in terms of, for example, if a changeover is occurring at home in the front driveway or at the curbside, restraining that person from entering the home of the person who dwells at that place, or attempting to prolong changeover, or attempting to engage in communication with the other parent at that changeover event. Again, designed for safety and protection, but also to ensure that the changeover that is occurring in a swift, business-like manner, likely to minimise conflict and aggravation between parties. In terms of changeover arrangements as well, thinking about time on particular days and not getting caught out when we're looking at changeover that might occur at school. For example, where there is usually school collection, which is absent parental involvement, so changeover is just happening at the end of a school day or at the beginning of a school day, thinking about what is the default if a child isn't at school that day, or if a child is at home because they're sick, what's the default? What's the coverage in our order for changeover if a school-to-school changeover can't occur on that particular occasion? So having a default mechanism, I think, is really useful there. In terms of changeover, if it's the case that children need to transition with belongings or items, perhaps considering whether or not our suite of consent orders needs to include provision for items to be moving with children, or if parents are going to have their separate arrangements to change over those items of property without children necessarily being involved. Lastly, I just want to think about some of the special celebration days that are necessary and are often so requested to be included in suites of parenting orders. By these, I'm meaning Christmas, birthdays, Easter, New Year's Day, other special religious festivals in family life, Father's Day, Mother's Day, and the like. When I take instructions from a client, I will inevitably sit there and ask them what's important to them in terms of these special celebration days. Often they can't think clearly at the point where they're being pressed around these issues. So having a little checklist with them that I've pre-thought about and can assist them through as they provide instructions to me is often helpful. That's important because it means that I'm not going to forget something in the drafting of my orders, or at the end of a matter, a client's not going to say to me, you failed to advise me, Jeff, in relation to these particular things, and therefore you've provided me with a product that is deficient because it doesn't address these matters. But even within those special celebration days, when you unpack and peel back the layers of the onion there's just so much detail around timing of changeover on those days. What's to occur? Where is the changeover to happen if, for example, the family is involved in a special religious service at a church or celebrating at a particular location? Or when it comes to special celebration days, I'm holidaying in Vanuatu, and so you're not going to see little Johnny on his birthday. Just covering and workshopping those scenarios with the client, I think, will give us clarity around the subject matter that we need to be addressing and the detail within it. within our suite of parenting orders that we have to draft. I won't necessarily refer to it as a special celebration day, but one of the issues that comes up with holidays for kids and schooling is pupil-free days. And I've recently had a matter whereby there was an argument that when it came to calculating school holiday periods, one needed to exclude all special celebration days like Christmas and New Year's Day and pupil-free days that fell within that holiday period. You had to exclude those things, apparently, as it was alleged, from the calculation of what a school holiday was, even those days fell within the school holiday period. If, therefore, private schools, for example, have a bunch of pupil-free days which fall in holiday periods or on the fringes of those holiday periods, think about whether or not it's necessary to include a specific order in your suite of orders which confirms whether or not pupil-free days will be counted and included as part of that holiday period or otherwise. Whatever the parents want, but simply having clarity about it, I think, is key. I could probably talk for a long time around tips and traps and things that I've fallen foul of and that I've seen as well in the drafting of parenting orders. But have a read of my paper. There's some things in there which hopefully will be of some guidance and assistance, and perhaps even at minimum just some prompters as you track forward into the future. So as we conclude, I guess where we come to is this: a well-drafted parenting order is going to be one that meets the prize or achieves the goals that we've identified today, creating certainty about arrangements for kids, which in turn will aid in the minimisation of family conflict and dispute. We do that by defining and creating certainty of legal obligations that are imposed upon parents and carers, and our orders as drafted are desired to be enforceable. Can we stand up and prepare and prosecute a contravention application without being criticised, hosed out of court for poor drafting and an inability to prove something to a quasi-criminal standard that has alleged to have occurred? Nothing worse when we've got to advise our client that, yeah, look, while they spent a whole bunch of money on us drafting these orders, we actually can't take action to either seek some sort of remedy or sanction for non-compliance or rectify a problem that's ongoing. So all the best to you in terms of drafting in the future. It's good, I think, to go back to basics and to think about some of those aspects, particularly with a reflection on the new law as we now find it in the Family Law Act. That's all I wanted to talk about today, but what I'm going to do now is I'm just going to jump into the questions and answers section and see if any delegates today have come forward with any questions that they wanted to ask me. So just bear with me to see if I've got anything there. All right. I can see one question there, and the question is this. Jeff, do you think that with the introduction of the new amendments to the Family Law Act, the court is more likely going to, I think what it's asking, more likely going to allow relocation of children nationally or internationally? So is relocation going to be easier or harder under the new law? A couple of things about that, I think, in response. Firstly, I think in matters where there is significant family violence and ongoing exposure to violence, which creates safety issues, picking up on that new terminology that we've read in the law, I think those matters may be matters where the court thinks perhaps more favourably around relocation. But I don't think that the changes to the law necessarily mean that relocation is going to be easier. I think time will tell. We're only about 8 weeks into the introduction of the new law. We've not yet received any guidance from the full court around how the court is to implement the changes to the legislation on this topic in particular, what is safety? What does it mean? What is to keep someone safe mean in a particular circumstance? And also, I think we're waiting on a good and good style judgment, which maybe will create a new pathway that the court has to apply, which might also give us some guidance on where to from here. There's another question that's come in. It reads as follows: in the absence of a presumption around equal PR, how do you think the amendments will mean the court will make decisions around sole or equal PR? What should we aim to establish in our applications to satisfy the court one way or another? Yeah, good question. Thank you. So firstly, I think the court will look at the history of decision-making to date. So that will import how are these people behaving with each other generally? Is there a history of being able to make decisions when those needs have arisen for those kids in the past? Leading evidence around, look, we had to make a decision about school enrolment. We had a Barney at the hospital when Kate needed to have an operation. We had a dispute about which doctor to go to. We couldn't make a decision about getting therapy for a child, and therefore the child missed out on that therapy. Those examples are all probably indicators that if the court were to make an order for equal decision-making or joint decision-making, that there's going to be problems. So if we can lead evidence around either it's been smooth sailing to date and I can communicate, as opposed to troubled waters, long-standing difficulties, simply can't communicate, that's probably going to point one way or the other. I certainly think that the existence of family violence and safety issues where that has historically to date under the old law been a killer when it comes to equal shared parental responsibility, it probably will be a killer even more so now, because I think it would be very easy for a court to be satisfied that within the context of proven family violence, that it's unsafe for parents to need to communicate with one another and attempt to make joint decisions. I also think in cases where there has been extremely poor and exclusionary behaviour or conduct by one party designed to shut the other party out from having any involvement in the life of children, evidence of that poor conduct, evidence of that sidelining may be of benefit to the other party as they seek an order promoting joint decision-making. And certainly there has been under the old statute, and I expect there will be under the current law, even cases where there has been family violence established and proved, where the court has, particularly on the recommendation of expert evidence, still made an order which requires joint decision-making for the reason of not enabling one parent necessarily to call the shots if there is a concern about that being done for ill intention or to shut the other parent out. But I certainly think as well, with the introduction of the new law and the abolition of the presumption of equal shared parental responsibility, I think it's brought the focus back more to, should there be an order for sole parental responsibility? Whereas before, under the old law, someone asking for sole parental responsibility was often seen as the challenger, someone that was going against the grain because we had this presumption. So I think actually the amendments mean that the court will be thinking perhaps more closely on the legitimacy of those applicants who do come to the court seeking an order for sole parental responsibility. And I think that's probably a good thing, particularly in the climate in which we live, where the prevalence of family violence in high conflict families that we so often see is just so significant.